Thank you, Your Honor, and may it please the Court. My name is Tim Volpe. I have with me at council table my partner, Bill Welke, and also Caroline Prieto of my office. I'd like to reserve 3 minutes in rebuttal, if I may, please.
Okay, well, since you can see that we're so overloaded with cases this morning,
Okay, thank you, Your Honor. This case is somewhat straightforward. A Colorado decedent travels to Florida. He is a pilot. He seeks advanced pilot training from an outfit that is my client, Airline Transport Professionals in Broward County, Florida. Tragically, he undertakes some training, and there is a two-plane crash killing all 4 of the folks who were on board. The other plane was also a flight school student with a trainer on board. Before this gentleman, Mr. Sachs, commenced his training, he executed a fairly simple and straightforward one-page agreement. That agreement both acknowledged the inherently dangerous nature of the advanced flight training that he was about to undertake, including circumstances and maneuvers where emergencies would be mimicked, and it also provided for a bilateral provision regarding waiver of ordinary negligence claims. And then in a single box on this one-page document entitled Agreement to Arbitrate, Mr. Sachs agreed to arbitrate any claim, dispute, or controversy, whether in contract, tort, or otherwise, that he may have, essentially relating in any way to the flight training he was to receive from my client.
You know, was there something else that with the flight training? Because all this talks about is inherently dangerous activities, understands that they can demonstrate proficiency, that, I mean, there's no, and then it says this, and it has the various boxes, and then it says this is the complete agreement of the parties, but I don't see that there's anything like flight school says, we're going to give you this many hours of training, or we're going to do this for you.
Well, Your Honor, I was not involved in the trial of this case below, but there was no evidence whatsoever adduced at this hearing that was held other than this singular document. It is my understanding, and I don't profess to have complete command of all of those facts that are outside the record in this case, but it is my understanding that obviously there are different kinds of training that can be obtained from my client. My client's business is essentially trying to train people to become airline pilots and commercial pilots of one sort or another.
There was some reference that I can't remember what I read in whose brief, that this was actually signed after they made the agreement, or he decided to come here. This was actually signed here, so obviously something had to, he didn't just show up on their doorstep.
Correct. That's absolutely correct. And in fact, I would say, in fairness to my learned opposing counsel, there are references in the briefs to circumstances about when this document was executed relative to the point in time in which the flight training commenced, none of which are in the record. There is no evidence whatsoever. The only evidence that was of record in this case was this document. There was no testimony about the circumstances of its signing, no testimony about the other documents that were executed, no testimony about the kind of training, no testimony about the degree and circumstances of Mr. Sachs's training himself as a pilot.
Counsel, would you quarrel with the notion that the Florida arbitration does not apply?
I would quarrel with it, but only to some degree. The quarrel, I think, has to do with the fact that the specific language that's used in the arbitration provision suggests that it is Georgia law that is to apply to matters substantively in the course of the arbitration. I think that the issue that we're grappling with here as to whether or not 682 would apply or not is a close call.
Did the trial judge look at Georgia law at all in reaching any conclusions?
He did not.
So he determined that as I understand it, that the agreement was unconscionable procedurally and substantively, although not articulating his reasons, not taking any evidence.
Correct.
Just on the face of the document.
Correct. He made his determination without any evidence whatsoever, other than the agreement itself.
All right. Having said that, then, what is your position as to whatever we end up doing? Should Georgia law apply, and if so, Does the case get sent to Jacksonville? Does the case, and then does a Florida court apply Georgia law? Look at the Georgia Arbitration Act, look to the Federal Arbitration Act. These are unanswered questions because the record is pretty scant on what the judge did other than to say he found the agreement unconscionable.
Well, first I think that the answer to the question is that we don't see any basis in the law or in the briefs filed by the appellee as to why this case should not be in conformity with parties' agreement filed and dealt with in state or federal court in Jacksonville, Florida. The circumstances of this case, Colorado resident, Colorado personal representative chooses through her lawyers to bring suit in Broward County contrary to the express terms of the choice of venue provision in this agreement. And
is there an ATP, is there any connection with Jacksonville?
yes, ATP has offices throughout the country, including in Jacksonville.
We're not sending them up to some place which is totally unconnected.
No.
Wouldn't you think that would be a problem with a venue provision if they said, okay, venue is in Ketchikan, Alaska?
Yes, ma'am. I think so. Obviously, as you know from this court's decisions, the standard is not simply that the chosen forum be less convenient or even be inconvenient or more expensive to litigate in. And here we're not talking about Ketchikan, Alaska. We're talking about the difference between Broward County and Duval County.
But if there was no connection to ATP, still wouldn't it be, could you send them up to Pasco County or to Columbia County when there's no airport even there?
No, I think that not to confuse the two issues, but I think the issue here is contractual agreed upon venue terms versus trying to evaluate where appropriate venue would be under the venue statutes. In this instance, they selected Jacksonville, Florida, both as the site for the arbitration.
A ground for procedural unconscionability of the arbitration if the venue is in a completely inconvenient location?
I haven't seen a case that suggests that parties' contractual selection of a particular venue would lead to any conclusion of procedural unconscionability. In fact, the cases go the other way. Freedom of contract is the countervailing balancing test for this court and others in evaluating the propriety of any case under a procedural unconscionability standard. And here, the parties did, in fact, freely contract for that site to be used, and it does have reference to where ATP, who does business all over the state and, in fact, all over the country, has one of its principal operating subsidiaries.
Let me go back to arbitration for just a minute.
Yes, ma'am.
Analytically, we would look at whether or not this is an unconscionable clause under Florida law. Is
Correct.
that correct? Okay. Now, could we, for the purposes of argument, say that applying Georgia law might be substantively unconscionable because of the difference in the types of remedies available in Georgia versus Florida because of their, whatever it is that they do with the wrongful death, their difference in how they interpret the comparative negligence?
Your Honor, I haven't seen any instance that suggests that substantive unconscionability can be based upon some difference in that law. We look long and hard at this question of public policy. As you know, there's some tension in the law about what should be done under these circumstances. Do you evaluate one of these situations based upon whether there is a public policy question, where public policy might be offended by enforcement of the specific agreement in question, versus simply looking at it from a perspective of unconscionability? I frankly believe that it's a bit of a stretch to evaluate each one of these cases predicating some basis for substantive unconscionability on whether or not there is something that offends public policy.